right. Well, thank you, Artie, and good morning, everybody. Welcome. Thank you to Duke for inviting me to speak this morning. The topic is one that is of interest to many people, and what I'm going to try to do with my opening remarks here is just set the stage for where we are at the PTAB and let you know about the things that have been happening at PTAB related to the AIA trial proceedings. And one thing to start with is just who we are and where we are and what we're working on. So I'll start with just an opening slide of the USPTO locations where you can find judges of the Patent Trial and Appeal Board. That would be all of the locations of the USPTO. We have judges in each of the satellite offices, including the permanent offices in Detroit and Denver, and we have judges at the temporary locations in Dallas and Silicon Valley. They will remain once those permanent offices open. You can see that on the next slide, the number of judges that we have has been growing, and you'll see a noticeable spike after between 2010 to 2012, and right in there is the passage of the AIA, so we had already been ramping up in anticipation not only of the AIA but also to meet the ex parte appeals backlog that we have. I won't be talking about our ex parte appeals jurisdiction this morning, but know that it's also a substantial motivating factor for us to continue the hiring, and so you can see that we've gone from a pre-AIA strength of on the order of 80-some judges to a current strength of 230 and growing, so nearly quadrupling the size of the board. In addition, back in the pre-AIA days, we were only in the Virginia office, and you can see that we've spread out across the country. The demographics are just here. You can see that the majority of the judges are still in the Virginia office. However, we have substantial numbers in each of the satellite offices, with California being the largest of the satellites. And we also have a number of judges who are on full-time telework, including the purple slice called TEAP. It's a special full-time telework program for those of you who weren't familiar with the acronym. This is what the judges are working on. The allocation's really in terms of hours spent, because some judges spend time working in multiple jurisdictions. So you can see that about a third of the judge strength and in terms of number of hours is spent working on the trials. About half of it is spent working on our appeals, and then various other smaller slices are spent working on the inter-parties re-exam appeals, of which there's still quite a few interferences, and then there are some who spend most of their time doing management functions. So we'll walk through some statistics here. One thing, though, that I'd like to say at the outset, because I know there's been much focus on statistics, and statistics can look differently depending on the slice that you look at, the time periods you look at, what you count in various slices, and what you count in different categories. The thing that I'd like to say, and just I want to make sure this doesn't get lost, is that at the Patent Trial and Appeal Board, we don't focus on the statistics. We focus on the case. We look at the arguments. We look at the evidence presented, and we make our determinations based on the strength of those arguments and the evidence. So the statistics fall out where they fall out, but there is no agenda. We are here merely to decide the cases under the law and the regulations as they exist. So with that in mind, I'd like to just first start with the slide that you are all familiar with, what we call our trial timeline, and then I will just point out some various current statistics at different points, starting with the filing of the petition. What I'd like to say, well, the first slide, unfortunately, the AIA filing numbers fall right at the dividing line of the screen. However, the thing that you will notice if you look at these numbers, well, first of all, the one that jumps out to you is in fiscal year, this is for fiscal year 2014, so it's for that year only. And that's our last fiscal year. It runs from October through September. In that year, there were 1,494 AIA petitions filed. At the same time, the Patent Office granted 326,382 patents. So you can see the relative size of the operation quite different. The percentages roughly track the technology centers, although some technology centers, the ones having to do with the computer arts generally or business methods, have slightly more AIA filings percentage-wise. But there's a rough correlation between the technology centers issuing the patents and the technology centers where the challenges occur. The next slide is one that you're probably familiar with. It just shows total number of filings over time. It's broken out, and I do apologize, it's a little hard to see here on the screen, but the purple bar is the inter-parties review. The light blue bar, this portion of the bar is CBMs, and then there's a very hard to see because it's a minor part for PGRs and derivations, of which there have only been a handful and have not yet comprised much of our docket. An open question, of course, as more of the first inventor to file patents issue, it seems natural that there will be more challenges under the post-grant review part of the statute. The other thing that you'll notice is that April of last year is the first time we crossed the 150 petition filing threshold, and we've stayed right around between 150 to just under 200 ever since. What will the future bring? That's an excellent question, but we would anticipate that it would probably not decrease dramatically, at least not under the current conditions. The next slide is one that we've also presented before, and this remains largely the same as it has before in that this is the technology breakdown. This one is for the current fiscal year through May 21st, and just showing by technology center where are the filings coming from. The largest percentage of filings comes from our electrical technology centers. The next largest is the mechanical business method technology centers, then followed by biotech, pharmaceutical, chemical, and there are still a few design challenges there in the mix. In terms of patent owner preliminary responses, the numbers here look very much as they have before, at least percentage-wise, where you can see both in IPR, CBMs, and PGRs, the number of filed patent owner preliminary responses vastly outnumbers the instances in which they were waived. So by and large, patent owners are choosing to file patent owner preliminary responses. I know in past discussions there have been discussions of pros and cons of doing it, but it looks as if patent owners generally are in favor of filing these. Generally, we at the board are in favor of these being filed also because it's a great opportunity to tell us why no proceedings should be instituted right up front. The next slide is the decisions on the petition. And good, the percent instituted is the one I'd like to focus on. What this chart shows, and I realize it's also a little bit busy, but we've separated each of the proceedings, the inter-parties review, covered business method review, derivations. We don't have the PGRs on there because there wasn't anything to report as far as trials instituted. And then we have a further breakdown for each type of proceeding by the fiscal year. And recall that even though fiscal year 2012, it was possible to file, that was the very first, there were only 2 weeks of that fiscal year in which it was possible to file. That's why this doesn't appear here. And what you can see, at least for inter-parties review, first of all, the number of trials instituted has been going up dramatically each year. That correlates with the number of filings that you saw on the prior chart and the number of decisions, just the sheer number going up. In fact, you can see that this year alone, through May, we're not even completely finished with the year. In fact, we're just halfway past. We've already surpassed the number or we're about to surpass the number of trials we instituted in the entirety of last year. So the numbers are still going up. You can also see the number of petitions that are joined went up. This is partially, in fact, the sheer number there is largely due to a phenomenon that we've been witnessing of families of patents being challenged. So there will be multiple challenges against multiple related patents, and then there's a request to join many of these. So the single challenge to a single patent is more of the minority these days. It's much more common to find multiple challenges against either a single patent or multiple challenges against multiple related patents. So the complexity is on the increase. The other thing that I'd like to point out is that the institution rate has generally been declining. This is for each of the fiscal years. It was 87% for our first full fiscal year of the trials. It is now running at 72%. The last column on the far right, I'd just like to point out, shows that the total number of decisions, this is whether it's a thumbs up or thumbs down, has increased, and you can see here the total number of decisions this year has outpaced the entirety of last year. And again, that fits with the number of filings that we've seen and just the general delay of the proceedings. You have a roughly 6-month pre-institution phase. If it's instituted, you then have a 1-year trial phase, so a total of about 18 months roughly from the first filing through the final decision if the trial goes all the way through. And so what you're seeing today are the results of petitions filed 18 months ago. And if you go back to that chart on the filings, you'll see that 18 months ago the number of petitions was still on the rise. So that's just a general phenomenon that you'll see here through the proceedings. Next, on the final written decisions, these are for petitions that make it all the way through, and you'll see in a moment, in fact, the very next slide, that there are a great many that never make it to this stage. There are many ways not to make it. Let me just go to that next slide. This is one that you've seen before, and it has multiple bars that just indicates the progression through the proceeding. And this is as of April 30th, so it's about a month old. And what it shows if you count up the number of claims of the challenge patent in each of the 937 petitions that had completed, so it's completed either by terminating voluntarily, going to final written decision, reaching settlement, or not being instituted. There are multiple ways they terminate. You can see that less than half of those claims were challenged, and then of those that were challenged, about 65% ended up being instituted. Of those instituted claims, then about 38% were found unpatentable by the board. Another 14% were canceled by the patent owner. About 10% were found patentable expressly by the board. And the rest of them ended up remaining patentable largely through settlement. So that's just sort of a look at how things have moved through the proceeding. And a lot of the statistics you see show different percentages because they take a different view. If you stand at the institution phase and look only at trials that have completed, the picture looks a lot different than if you look at the overall picture, and that's where some of the differences and the different statistics come from. So I just urge you to be careful and understand what you're looking at when you see the statistics. Let me just, since I only have a few minutes left, run quickly through the rulemaking update. Recall that we're in the middle of a rulemaking process. We had a public feedback request, and we came out with a first set of rules that were a bunch of relatively easy to implement corrections. These were the topics. There are about 10 topics, but one of the 10 is a catch-all, and it did catch a lot of different comments. As I say, May 19th, our first package went into effect, although we'd actually implemented it through orders of the board earlier than that. The second package is going to address some of the more difficult changes. Things are currently on track for a July publication, although it's always a little dangerous to predict publication in the Federal Register because there are forces beyond our control that may move that timeline slightly to the right. But as I say, we're right now on track for a July publication of those changes. This is just the quick fixes, which I think you're already familiar with. The last thing I will mention, we still have a number of public outreach opportunities. We have board-side chats, although those of you who tuned in yesterday found we actually, unfortunately, had technical difficulties. It'll be rescheduled. But we do have an August board-side chat to discuss the proposed rules. That's the one that I wanted to point out. Another thing just to point out, we had updated our website, and the last item that I'd like to point out is that there is a PTO subscription center. If you haven't signed up, there is a subscription center for the PTAB email blasts, but there are also subscriptions for other parts of the patent office, including patents, trademarks. If you go to this portion of the site or just use your favorite engine to find US PTO subscription center, you will find the menu, and if you haven't signed up, it's just something I would urge you to sign up for. So that concludes the presentation that I have, and I will turn over the floor now to Alan Marco for the next presentation.